to be free from unreasonable searches and seizures, and the second sets forth the requirements for the issuance of warrants, which grant law enforcement the authority to conduct such searches and seizures. Two parts. Simple, right? While this amendment caused little public or political controversy during the founding period, the Supreme Court has not had an easy time interpreting it. Okay, so let's talk about the physical penetration rule. Not what you might have thought. Physical penetration rule has nothing to do with other areas of the law. The court has generally adhered to the physical penetration rule for the first 150 years. So, from the beginning part of almost, 3/4 of American history, the physical penetration rule prevails. What is it? The prevailing view is that the Fourth Amendment did not restrict police searches and seizures unless law enforcement physically intruded on a person's property. For example, physically searching through a person's belongings or trespassing on private property. Right? Physical penetration rule. The court articulated this position best in its 1928 ruling in Olmstead versus United States, the first major electronic eavesdropping case to come before the justice. Right? So as technology changes and law enforcement gets more sophisticated, the physical penetration rule seems to perhaps run into some limits. So, here's what Chief Justice Taft, or whatever, says in Olmstead versus the United States. And we shouldn't be surprised with this, right? If you put someone who used to be in charge of the executive branch, in charge of, law enforcement and that sort of thing, you would expect this kind of rule. Federal agents have reason to believe that Roy Olmstead was importing and selling alcohol in violation of the National Prohibition Act. Oh, those were the days. To collect evidence against him, the agents, without first obtaining a search warrant, placed wiretaps on his telephone lines, and they did not set foot on his property. One tap was applied in the basement of a large office building in which Olmstead rented space, and the other on telephone line on the street outside Olmstead's home. So these wiretaps allowed agents to overhear conversations involving this activity. The Supreme Court ruled 5-4 in Olmstead in favor of the government. In the majority opinion, Taft said, the Fourth Amendment did not protect Olmstead's conversations because it conveys only searches of material things. The person, the house, his papers, or effects. Therefore, the amendment does not forbid what was done here. There was no searching, there was no seizure. The evidence was secured by the use of the sense of hearing, and that only. There was no entry of the house or offices of the defendants.
So the telephone isn't upstairs.
No, I'm just listening. One justice says later on, what if you're having a conversation, you're at home, but your windows are open, and I'm walking down the street, and I walk right by, and I hear you guys plotting a murder or something, right? Or discussing legal activity. I mean, I'm just hearing. So it's sort of like that. You're thinking of the telephone, wires. No, it's just, all the police are using is their ears. I like that, though. Taft would buy it. Brandeis's dissent in Olmstead is the famous dissent. And he writes, the makers of our Constitution undertook to secure conditions favorable to the pursuit of happiness. They conferred as against the government the right to be let alone, the most comprehensive of rights, and the right most valued by civilized men. To protect that right, every unjustifiable intrusion by the government upon the privacy of the individual, whatever the means employed, must be deemed a violation of the Fourth Amendment. So now he's thinking more broadly about privacy rights. To Brandeis, it was immaterial the agents had not needed to enter Olmstead's home or office to place the wiretaps. It was equally unimportant that the intrusion was in aid of law enforcement. He declared, the greatest dangers to liberty lurk in insidious encroachments by men of zeal, well-meaning but without understanding. Boy, that's a radical liberal if there ever was one, right? Chief Justice Taft is not happy with this. Though Brandeis's view lost out over the next 4 decades, criticism of the physical penetration rule, which allows wiretapping and overhearing and eavesdropping, grew. Criticism grows, and Brandeis's dissent picks up steam. the justices decided to reconsider this traditional physical penetration approach. Katz versus United States, 1967. All right, we mentioned Katz before, and I have to put this picture up here because my students don't know what this is anymore. And I have to go into the facts of this case in a way that, trying to get them to understand what this is. This is a telephone booth, I tell them. When you go inside and close the door, they're like, why? Why would you go inside and close the door? They can't even fathom such a thing, right? Then they say, why would you even talk to someone? We just do this, right? We don't talk anymore. FBI agents suspected Charles Katz of engaging in illegal bookmaking activity. In particular, they thought he was placing bets and transmitting other wagering information by telephone from LA to Miami and Boston. To gather evidence, they placed listening and recording devices outside the telephone booth Katz used to make his calls. Even though law enforcement officials had listened in on Katz's conversations without a warrant, federal attorneys used the transcripts of those conversations to obtain an 8-count indictment. Now, a couple years prior, in Griswold v. Connecticut, in 1965, I mentioned the Ninth Amendment before that. This was the case where they were talking about the right to privacy, and they were talking about it in the context of marital contraception in Griswold, but still the overall right to privacy. The court said that there are specific guarantees in the Bill of Rights that create various zones of privacy. So even though Griswold isn't directly related to criminal procedure, it is talking about this concept that Brandeis mentioned in Olmstead, privacy. But that's really what the Fourth Amendment is getting at. Okay? So Katz is 2 years after Griswold. So Katz and his enterprising attorneys are arguing that the glass-enclosed telephone booth is one of these constitutionally protected areas, one of these zones. The government argued that in previous cases, the justices permitted the warrantless use of bugs if agents did not physically penetrate an individual's space. Here, the FBI attached the bug to the outside of the booth that never invaded Katz's space. Right? So here we have a nice challenge to the physical penetration rule and this idea of zones of privacy. Right? Okay, how does the court come down? Justice Potter Stewart writes for the 7-1 majority, rejecting the physical penetration rule, which had prevailed in American law ever since all up until this time, 1967. And that's why you ever see the old movies, right? I love watching the old black and white movies with regard to criminal procedure decisions. The movies from the 30s and stuff. They're going to take you downtown, they beat them, they do all this stuff to them because it wasn't until the radical liberal Warren Court came in, right? Changed everything. So this is one of those decisions. The Fourth Amendment protects people, not places. What a person knowingly exposes to the public, even in his own home or office, is not a subject of Fourth Amendment protection. But what he seeks to preserve as private, even in an area accessible to the public, may be constitutionally protected. Now that's radical. That's completely different from what the court had said up until this point, right? Even if you're in public, but you seek to keep something private, it has Fourth Amendment protection. No less than an individual in a business office, in a friend's apartment, or in a taxi cab, a person in a telephone booth may rely upon the protection of the Fourth Amendment. One who occupies it shuts the door behind him and pays the toll that permits him to place a call is surely entitled to assume that the words he utters into the mouthpiece will not be broadcast to the world. To read the Constitution more narrowly is to ignore the vital role that the public telephone has come to play in private communication. Not anymore? Doesn't this apply to cell phones? No. Well, I don't know. I always look for a glass enclosed booth whenever I answer questions. Just to be safe. Just to be safe.
I was in a diner the other day, and I come in and sit down. There's a guy down at the end of the counter having this really wild conversation. And it sounded to me, forgive you guys, like he was a lawyer because of the terms he was using, what he was talking about. And I said, I ordered my breakfast, and the guy is still talking. I ate my breakfast, the guy is still talking. And I asked the waitress, what the hell was he doing? Because he ordered anything back, he just came in and sat on himself. And I got up and walked over to him, and I started to say something to him. I said, God, real story. And he looks at me and he says, this is a private conversation.
Well, is he right? Is he right under Katz? I mean, he has a right to privacy.
In a public restaurant, I don't think so.
No, he said
so many telephones were hard lines, private lines, was that ever into consideration?
I don't know. You're talking about, what do you mean specifically?
As of 1967, in that case, we decided to use the telephone to have a conversation. There were many other people that had access to that same line.
Yeah, I've heard of this idea that not only is the operator listening, but everybody picks it only one line or something, and everyone's attached to it. I don't know. I mean, that's a good question. That could be different. That could be a different issue. I know you're all thinking, oh man, I don't know what to do now, right? Don't worry, Justice Harlan has the answer for you. While Harlan agreed with the majority, he sought to make plain his understanding of the proper search and seizure test to apply to all situations. Okay? My understanding of the rule that has emerged from prior decisions is that there is a twofold requirement. First, that a person have exhibited an actual, subjective expectation of privacy. And second, that the expectation be one that society is prepared to recognize as reasonable. So the person on the phone has to have an expectation of privacy, and then we have to deem that as a reasonable expectation. It can't be unreasonable, right? There's your standard. That's now you apply that to your guy in the document, right?
After 20 minutes of open conversation, about 5 minutes, it's no longer private.
I mean, maybe we can society should reasonably say, well, that's not really private. He's being loud, he's in a diner, he could have stepped outside, he could have, gone somewhere else.
See, when I said something to him, then he got up and went outside and had a conversation out in the parking lot.
I would just follow him right up. Okay, so Harlan articulates the rule a little bit more clearly from the majority. Thus, a man's home is, for most purposes, a place where he expects privacy. But objects, activities, or statements that he exposes to the plain view of outsiders are not protected because no intention to keep them to himself is being exhibited. On the other hand, conversations in the open would not be protected against being overheard, for the expectation of privacy under the circumstances would be unreasonable. So if you want to have a private conversation, don't do it out in the open, right? Shut the windows so people walking by can't overhear it, right? I always make that mistake. I'm always on the phone, and my windows are open, and my neighbor upstairs, she hears everything, and I should have, shut the doors. I don't care. It's very bad. Very bad. This new expectation of privacy approach is still used to this day. So that's the standard. Reasonable expectation of privacy. Okay? And so that should be, they can apply that to any technology, right? And that's really what the law is, and that's something I try to teach my students, that what judges try to do is create rules, standards, tests that they can apply, right, to interpret the Constitution to various fact situations that may change over time. And so the good judges will do something like what Harlan is doing here, to try to articulate a test that can be applied for all time in all situations, right? That's what they're trying to do. And then, when the next case comes up, they can just apply this test to the new technology, the new fact situation. Yeah.
Now, what do you do with something like wireless, where it's out over the airwaves and can be intercepted by? I mean, that's something that we discussed in class. Students are close to my cell phone, so I'm talking, but yet you're shooting. You got to realize when you're using wireless, you're sending it out there.
Is that different than a telephone line?
Yes.
Yeah. You have less expectation of privacy. Society should expect you to have less expectation. I mean, that's the test now, right? So apply this as you're trying to do to the cell phone technology. Is it the same logic as a telephone line, or is it different? In other words, when you use a cell phone, is that different from when you use a hard line in terms of who you think might be intercepting the call? I kind of do. I kind of think when I'm using that cell phone, anybody can pick this up, right? So maybe there's an argument, a good attorney made the argument that you have a less reasonable expectation of privacy for a cell phone, and therefore it can be, right, intercepted more readily.
How does that apply to emails?
What about that? Everything is wireless now. So cell phones, emails, everything is wireless. What about that?
What if you only have a warrant for one party of the two? Is the other party protected or not?
So you have a warrant for one part of the conversation, you didn't leave it one. I don't know about that. That's a good question. I think it's the conversation. Do you know the answer to that?
No, in the Cass case, the only thing the recording picked up was Cass's voice.
Is that how they do it? I don't know. Yeah, I guess the warrant, that's right, because the warrant has to be specific. So you have to specify the warrant. Do you need both parts of the conversation or only one part? That's something a judge, that's the whole point of the warrant provision, right? The judge should be able to, it has to be specific. So the warrant should be specific enough. And I guess that's, you know, when law enforcement says they have a warrant, you're supposed to look at the warrant, and is it specific enough for what they're searching for, whether that's conversation or physical search, yeah.
When emails or cell phone conversations are picked up, are they ever picked up just randomly? I mean, can I pick up my cell phone and just happen to hear another conversation, or is this information only picked up by people with intent of invading someone's privacy?
Have you ever randomly picked up another cell phone conversation? I used to, it was a while ago, but I can remember in the early days it used to happen.
I mean, like, I just don't get someone else's email. Now, if I'm a hacker,
Sometimes I do.
you do.
No, that's a good point. Yeah.
But our solicitor has told us flat out, there is no expectation of privacy in email.
Well, you mean,
We
well,
are
it
not-
depends on what you're talking about. I mean, you're talking about maybe email sent from your work email address, versus a private email address. Who are you sending it to? I mean, there's different laws about these things. Are you emailing the terrorists? Because if you are, right? That's different than if you're emailing, you know, a family member about a birthday party. So it depends. Yeah.
Go back to that notion of two different people talking, and the warrant made this one. Does the other person who may inadvertently incriminate himself, does that fall into like a plain view kind of exception?
Yeah, we're going to get into that. If we get there, I've got all the exceptions. You're going to be amazed when we get here. Plain view doctrine, absolutely, is one of the exceptions to this issue of, you know, warrantless searches. Yeah, if the police, you know, if you're doing, this was the thing that you mentioned before, this Kilo case, which a guy growing the marijuana, the police used infrared technology to see through walls. And that wasn't in plain view. But if you're growing marijuana in your backyard and the police fly over in a helicopter and see it, then it is in plain view, right? So they can't use infrared technology, but they can fly over your backyard and look in, right? So you just have to be smart when you're doing all your illegal activities. This is why the kids love this stuff. They love this area.
The current wiretapping issues that are going on right now, is that part of the clear and present danger clause of, you know, it's being to do illegal searches and seizures as long as there's clear and present danger to the United States?
Well, I mean, I think you've got a number of concepts in there. There is another exception to the search requirement that involves present danger, or danger being present is to allow police to search. But that's different than the clear and present danger test of First Amendment speech law, which is, so I mean, there's not, but let's get to those exceptions, because I think you're starting to get at some of these exceptions here. So let's plow ahead. All right, I know the Cass is a good case. This is a very thought-provoking case to teach. Now, Justice Black dissents, and Black wants to get at this intent of the framers. Hey, you liberal activist Warren Court justices, you're going too far. The words of the Fourth Amendment protect persons, houses, papers, and effects against unreasonable searches and seizures. These words connote the idea of tangible things in size, form, and weight, things capable of being searched, seized, or both. The second clause of the amendment still further establishes that its framers' purpose to limit its protection to tangible things by providing that no warrants shall issue with those particularly describing the place to be searched and the persons or things to be seized. A conversation overheard by eavesdropping, whether by plain snooping or wiretapping, is not tangible, and under the normally accepted meanings of the words, can neither be searched nor seized. And, to take it a step further, he explained that wiretapping was not known to the framers, of course, but eavesdropping was, okay? There can be no doubt that the framers were aware of this practice, and if they had desired to outlaw or restrict the use of evidence obtained by eavesdropping, I believe that they would have used an appropriate language to do so in the Fourth Amendment. So they knew, law enforcement used that back then, standing under the windowsill and listening in, or that sort of thing. So even though technology changes, the principles are the same. Black says. You can still apply the intent of the framers of the Fourth Amendment to know that eavesdropping is not protected, and government, law enforcement should be able to wiretap and eavesdrop and have it not be a violation of the Constitution, right? 1967. In interpreting the Bill of Rights, I willingly go as far as a liberal construction of the language takes me. Black is very liberal in a lot of areas, like free speech, very absolute in its protections of it. He says, but I simply cannot in good conscience give a meaning to words which they have never before been thought to have, and which they certainly do not have in ordinary usage. I will not distort the words of the amendment in order to keep the Constitution up to date, or to bring it into harmony with the times. These are phrases he's taking from the majority, right? It was never meant that this court have such power, which in effect would make us a continuously functioning constitutional convention. Now this critique that Black is using in the late 60s here on some of these Warren Court decisions is the current critique that you hear time and again from justices like Scalia and Thomas, right? That we are being ruled by a bunch of activist judges who are deciding what they think the Constitution means. Not based on the intent of the framers or anything else, but based on the evolving standards of the day and, this kind of stuff. And that, Scalia and Thomas and Black would say, is very dangerous for American democracy because it takes power from people and puts power in the hands of five people. Okay. Finally, Black criticized the court for continuing the broad construction of privacy, which we mentioned in Griswold versus Connecticut. He dissented from that decision 2 years earlier. No general right is created by the amendment so as to give this court the unlimited power to hold unconstitutional everything which affects privacy. Certainly the framers, well acquainted as they were with the excesses of governmental power, did not intend to grant this court such omnipotent lawmaking authority as that. The history of governments proves that it is dangerous to freedom to impose such powers in courts. Now, the post-Katz exceptions. The Supreme Court has recognized that the requirement that police seek out and convince a judge that probable cause exists to justify search and seizure is, at times, just not practical, right? We mentioned a couple of those earlier. As a result, the court has carved out numerous exceptions to the general principle that police should obtain warrants to conduct searches. At the same time, though, the court has also placed limits on this. So let's discuss a few of those. Search incident to a valid arrest. So if there's a valid arrest taking place, they can search, right? They can search the person, they can search the immediate area, right? This is to protect the safety of the police officer. The court has also imposed two limits, though, right? It has to take place only during the time of arrest. They can't leave and then come back to the spot and search without a warrant. It has to be just for their immediate safety at the immediate time, and just the immediate area under the person's control, and not go beyond that. So there are limits to that. And then as you read this stuff, you start to think, this is what lawyers look for grounds for an appeal, right? It's procedures that were not followed by police officers, right? Loss of evidence searches. In situations where they must act quickly, the police can search in order to preserve evidence before it is lost, to preserve evidence from being destructive. So if the evidence is, people try to eat the evidence, right? What happens there? There's a Supreme Court case about this, right? Can the police induce vomiting or force surgery to get the evidence out of you? No, the court has said that goes too far, but blood tests are okay, right? Consent searches. The police can search if given consent. This is the first thing I tell all my students. If the police say, can we come in and look around? You say, no, right? You don't do it. There are all kinds of cases where innocent people who thought they had nothing to hide, the police came in and searched and found something that wasn't there before the police came in to search or whatever. So, you don't have to give consent. If you do give consent, police can search, but they must meet two criteria. Permission must be freely and voluntarily granted, so it can't be coerced, and the individual granting consent must have the authority to do so. And the police can't lie to you or use trickery or else that search is thrown out. Safety searches. It's again, the patting down of the suspect to remove the danger that might be present. Hot pursuit searches. You see these in the movies all the time, right? Someone's suspected of somebody runs, well, then you can pursue them. And if they run into a private residence, you can go into that residence, right? If they get into the car, you can go in and follow them if you're in hot pursuit, right? evading arrest. The plain view doctrine, right? That's a very controversial rule, that if the police officers are present and items subject to seizure are openly visible, they can seize those articles without thought. Right, so if they're arresting you for one, or stopping you for one reason, and then there's some illegal activity, and they just see it, too bad, right? They don't need a warrant, they can seize it, and you're in trouble there. So keep stuff out of plain view, right? Keep it hidden is the idea, right?
Is it all five senses?
Sorry?
Is it all five senses?
Yeah, we're talking about five, what are the five senses? Hearing.
Smell, taste.
Boy, this is, we're getting, I like this. This is good. Yeah, I think, the thing about the marijuana use with the infrared technology, that did involve one of those, right? But again, the reasonable expectation of privacy, right? These are the exceptions to that standard. So that's really the standard. The place searches, right? There are less places. This is where, if you're going to get into this with your students, school, right? There are certain places that have less protection than other places, and so there's a lower level of the lower standard. So you have, I have listed a bunch of them here, right? Prisoners in cells, customs inspections, the border, the airport, students in school. The court has given police broad latitude in these, in car searches, and that's the one that everybody loves to talk about, right? Is searching the cars. And the justification is the police have more latitude to search cars because cars are mobile and can quickly leave the jurisdiction of police. Car windows allow others to look in, and drivers have a lower expectation of privacy in cars than they do in the home. And the government has a pervasive interest in regulating cars because they're dangerous or whatever, right? Okay, so that's why there's a lower expectation there. And so there are a whole bunch of exceptions for cars. Routine traffic stops do not justify a search of the automobile, but if police have probable cause to believe a crime has been committed, then they may search the car. Police may stop cars at checkpoints, right? Even if those checkpoints are merely informational, right? But they can do that too. So, and that's because there's this unique situation involving cars. Okay, but let's move on to the exclusionary rule, which we mentioned before, Brett mentioned before. Now, the exclusionary rule is really interesting because what happens if the police violate your rights and seize evidence illegally? Well, then it should be thrown out, right? It shouldn't be. That's the exclusionary rule. This is a judicially created principle. It's not written down in the Constitution. It's a judicially created principle that reduces the incentive police might otherwise have for violating search and seizure rights. The exclusionary rule holds that evidence gathered illegally may not be admitted into court. It's excluded from use by prosecutors in attempting to establish the suspect's guilt. I mean, think about that. How many movies have we seen where that doesn't matter, right? Law enforcement still goes ahead and violates your rights to gather evidence. They have no intention of using it in court. They just need to get some more evidence here, maybe because they need to get an indictment, and in indictments, we'll talk about in a second, they don't have to follow these procedures, right? Or maybe they just need some evidence that will lead them to other evidence that then they can get a warrant for and use and so forth. So, police can still get around this stuff if they want to, but the idea is that it can't be used in court, right? The rationale behind the rule is straightforward. If police know that the evidence produced will be of no use, then they will not violate the Constitution. But we know better. We know that they still do that. Yet until the rule's development in the 20th century, law enforcement officials faced no federal punitive measures for conducting illegal searches and seizures. Unless individual states impose some form of redress, the police were not held liable for their activities, and unconstitutionally obtained evidence was not excluded from trial. That's why I love watching those old movies. Weeks versus United States, 1914. The law begins to change in 1914. In that case, federal law enforcement went to Weeks' house and without a warrant carried out boxes of his papers, documents, and other possessions. The court excluded the evidence. Justice Day held, if letters and private documents can thus be seized and held and used as evidence against a citizen accused of an offense, the protection of the Fourth Amendment declaring his right to be secure against such searches and seizures is of no value, and so far as those thus placed are concerned, might as well be stricken from the Constitution. So in that case, they just went to this guy's house and took all this stuff and looked through everything for some violation of the law. So with this conclusion, the court created the exclusionary rule. But Weeks was a federal case. What about state and local cases, right? Where nearly all of the criminal activity takes place. This is the incorporation question. And the court first reached that question in Bull versus Colorado, 1949. This case involved a Colorado physician who was suspected of performing illegal abortions. Because this is pre-Roe versus Wade, right, when the states criminalized abortion. Because the police were unable to obtain any solid evidence against him, the deputy sheriff surreptitiously took Wolf's appointment book and followed up on the names in the book. The police gathered enough evidence to convict him. Wolf's attorney argued that because the case against his client rested on illegally obtained evidence, the court should dismiss it. To implement his arguments, however, the justices would have to apply or incorporate the Fourth Amendment and impose the exclusionary rule on the states, right? So see, now that we understand this incorporation question, we see this is a difficult question. It's a separate question almost, because this is not a federal case now. This is a state and local case. So what did Justice Frankfurter say in this case? He agreed to incorporate the Fourth Amendment. To be secured against unreasonable searches and seizures was deemed a fundamental right, basic to a free society, he said. And that's why it should be held to the states. And provisions of the amendment apply to the states through the due process clause of the 14th Amendment. However, here's the big however, the court refused to hold that the exclusionary rule was a necessary part of the Fourth Amendment and upheld Wolf's conviction. The rule was one method of enforcing search and seizure rights, but it was not the only one, Frankfurter said. In other words, although state law enforcement officials must abide by the guarantees contained in the Fourth Amendment, judges need not use a particular mechanism, such as the exclusionary rule, to ensure that police comply. Indeed, 2/3 of the states did not use the exclusionary rule at the time of this decision. So the Fourth Amendment is incorporated, but not the exclusionary rule. They're two separate things. So presumably there could be other enforcement mechanisms. And in fact, in Britain, they still don't have the exclusionary rule, right? They have rights of civil damages. You can file a lawsuit against the police and sue them. That's supposed to stop the police from legally searching. Frankfurter, no, there's a lot in England where there was no exclusionary rule in the states, and the majority which rejected the rule. Yes, there we go. Check on police behavior. States were left free to adopt whatever procedures they wish to enforce search and seizure rights. The exclusionary rule was not interested. So this is 1950s. This is not that long ago. But let's get to math. Now, math is the big case. Everybody knows about Dolly math. The kids love, this is a good one to teach because the kids love the fact situation in math, right? There's the house. It's such a nice house. Nothing bad can go on there, right? Look at the awning, and it's so pretty. It's well maintained, the landscaping. It's hard to imagine. And look at these nice folks here. These are good-looking folks. All right, Dolly Mapp is a woman in her early 20s. She's carrying on a number of illegal activities in her Cleveland home. For several months, the police had attempted to shut down her operations, but apparently Mapp was tipped off because each time the police planned the raid, she eluded them. Right? She was really savage. So one day, Sergeant Carl Blau shows up in plain clothes, and he tries to, Dolly, let me in, We know what you're doing in there. We know that you have a fugitive from justice. The fugitive was suspected of bombing the house of an alleged Cleveland numbers racketeer, Don King, who later became a boxing pro. When Blau arrived, Matt refused to let him in. Do you have a warrant? No, Dolly, you gotta let me in. We know he's in there, right? So she knew what she was doing. So DeLau goes back to his car, he radios for backup and a warrant, and he keeps the house under surveillance for 3 hours. He's hanging out there, right? Meanwhile, Dolly Mapp calls her attorney, and he shows up just as the police, again, this is 3 hours later, right, knock on the door. Mapp was upstairs, and she did not want to answer the door. Police forced the door open. Mapp's attorney was not allowed to enter the house. Hearing the police break in, Dolly runs downstairs and she starts fighting with them, right? And Sergeant DeLau says, "We have a warrant here, Dolly." She grabs it from him and she shoves it down her shirt, right? And the melee breaks out, there's punches and fighting, so they take her, they handcuff her, they take the warrant right back out of her blouse, and she's arrested. Then they search the house, and they don't find the fugitive they're looking for, but they find some allegedly obscene pictures which were illegal to possess under Ohio law. At the trial, the prosecution did not produce the search warrant, and no explanation was offered for the failure to do so. but Mapp was found guilty of possession of obscene materials and sentenced to prison. She appeals to the Supreme Court on First Amendment grounds, right? The obscene pictures are free speech. But the justices didn't really care about that. They liked this idea of this search warrant and the search and seizure issue better. So that's the issue they wanted to decide in the case. All right, so what does Justice Clark say in this case? He explained that the facts that supported the Wolf Court's decision not to incorporate the exclusionary rule were no longer controlling. So between Wolf and Mapp, in 47 and 61, Clark is saying that other states have changed their ways. And so in Wolf, it was 2/3 of the states weren't using the exclusionary rule. Now Clark says more and more states are adopting it. Indeed, he says California, in adopting the exclusionary rule, explained that other means of protection against police violating search rights didn't work. Okay? And so the exclusionary rule is the only way to enforce the Fourth Amendment. Since the Fourth Amendment's right of privacy has been declared enforceable against the states, through the Due Process Clause of the 14th, it is enforceable against them by the same sanction of exclusion as is used against the federal government. Were it otherwise, then justice without the Weeks rule, the assurance against unreasonable federal searches and seizures, would be a form of words, valueless and undeserving of mention in a perpetual charter of inestimable human liberties. So too, without that rule, the freedom from state invasions of privacy would be so ephemeral and so neatly severed from its conceptual nexus with the freedom from all brutish means of coercing evidence as not to merit this court's high regard as a freedom implicit in the concept of ordered liberty. And there's that phrase from Hoffman versus Connecticut, right? This court has not hesitated to enforce as strictly against the states as it does against the federal government the rights of free speech and a free press, the rights to notice and to a fair public trial, including as it does the right not to be convicted by use of a coerced confession. And nothing could be more certain than that when a coerced confession is involved, the relevant rule of evidence, rules of evidence are overridden without regard to the incidence of such conduct by police. So if police coerce a confession out of you, if they beat it out of you, that confession is excluded in court. And Clark is saying the same should apply for illegal searches and seizures. It makes sense. So if you think about that, if the Constitution guarantees, protections against coerced confessions, then the logic about search and seizure should be the same. Exclusion, right? Okay. It's a logical argument. Moreover, holding the exclusionary rule is an essential part of both the Fourth and 14th Amendments is not only the logical dictate of prior cases, but also makes very good sense. There is no war between the Constitution and common sense. Presently, a federal prosecutor may make no use of evidence illegally seized, but a state's attorney across the street may, although he supposedly is operating under the same enforceable prohibitions of the same amendment. Thus, the state, by admitting evidence unlawfully seized, serves to encourage disobedience to the federal Constitution, which it is bound to uphold. So it makes no sense to think that, right across the street, federal prosecutors can't use certain evidence and state prosecutors can. That doesn't make sense, even though both take an oath to uphold the Constitution of the United States. There are those, and now what's the counter-argument to the exclusionary rule? Dolly Mapp goes free, right? She's a criminal and she gets to go free. And so do all criminals who actually did do something bad, but if police don't follow proper procedures, then that evidence is excluded and they go free. And so the court wants to address that. There are those who say, as did Justice then Judge Cardozo, that under our constitutional exclusionary doctrine, the criminal is to go free because the constable has blundered. In some cases, this will undoubtedly be the result. But there is another consideration, the imperative of judicial integrity. The criminal goes free if he must, but it is the law that sets him free. Nothing can destroy government more quickly than its failure to observe its own laws, or worse, its disregard of the character of its own existence. So that's what we're talking about here with the exclusionary rule. The potential that criminals go free versus following proper procedures so people's rights aren't violated. Right? Justice Black is concurring. Now, he dissented before, right? In Katz. Well, this is before Katz. He says, I'm still not persuaded that the Fourth Amendment standing alone would be enough to bar the introduction into evidence against an accused of papers and effects seized from him in violation of its commands. So in Wolf, he's with the majority in Frankfurt not incorporating the exclusionary rule. But he says, Reflection on the problem, however, in light of the cases coming before the court since Wolf, has led me to conclude that when the Fourth Amendment's ban against unreasonable searches and seizures is considered together with the Fifth Amendment's ban against self-incrimination, again, the logic of the excluding the forced confession is the same as here, then a constitutional basis emerges which not only justifies but actually requires the exclusionary rule. So he's changed his thinking because cases since Wolf have undercut the principles of not incorporating it, and now that the lawyers have gotten smart and linked it to forced confessions, we have to agree, right? Even Black has to agree. Okay. Justice Douglas concurs. You can read that. Another radical opinion. We have the dissents here by Harlan, Frankfurter, and Whitaker. Harlan explained that while fewer states adhere to the common law non-exclusionary rule, half still do. So yes, less are doing it, but still half do. The question remains, as it's always been, one of state power, not one of passing judgment on the wisdom of one state course or another. In my view, this court should continue to forbear from fettering the states with an adamant rule which may embarrass them in coping with their own peculiar problems with criminal law enforcement. So very much a states' rights. Let the states do what they want here. Okay? And there's some more there that you can look at. All right, let's look at the exclusionary rule exceptions, right? Chief Justice Warren comes on the court, and we have the other liberal justices in the 60s making these decisions like Katz and so forth, but they leave, and they're replaced by more conservative justices. Chief Justice Warren Burger, William Rehnquist comes on the court, and the court's jurisprudence begins to change accordingly. Was MAP going to be overruled is the question. And the answer so far has been no. In United States versus Kalanji, but there have been exceptions made, right? Gutting was scaling back the rule. The justices said that the exclusionary rule did not apply to grand jury hearings. So you could illegally seize evidence and use it before the grand jury. But you know, grand juries can consider rumor, hearsay, anything, right? So getting an indictment is pretty easy, and that includes evidence not illegally obtained. Leon, 1984, the court ruled that evidence seized by police acting in good faith with a warrant is admissible even if the magistrate erred in issuing it. So if the judge messed up and should not have issued the warrant, we find that out on appeal, but the police had a valid warrant and acted therefore in good faith, then that evidence can be used against you. Wow. How do you like that one? United States versus Nix, the same year. The court established the inevitable discovery exception. Evidence discovered as the result of an illegal search can still be introduced in court if it can be shown that it would have been found anyway. We would have found this anyway, later on or something. How about that exception? Illinois versus Kroll, 1987, the court allowed evidence seized by police who conducted a search pursuant to an unconstitutional statute. So if the law allowing the search is found there later on to be unconstitutional or invalid, but you conducted the search based on that law, again, in good faith, and it's allowed. Everything seized is allowed. In Hudson versus Michigan, 2006, the court considered the traditional knock and announce rule, right? Police, open up. Wait, 1, 1,000, 2, 1,000, 3, 1,000 for reasonable time for the person to answer, and then we can, right? Requires police with a warrant to wait a reasonable amount of time for the occupants to respond to a knock before going home. The court ruled 5-4 with new justices Robertson and Alito in the majority that evidence found after entry with a valid search warrant need not be excluded if police violate that knock and announce rule. Police, boom, and they just crashed in right and they seized them. They didn't really wait. And then they found a whole bunch of evidence. That can be used. That's okay. So say 5, right? All right, so the debate on the Fourth Amendment and the exclusionary rule illustrates the highly politicized nature of judicial decision-making, right? 5-4, in the most recent case there. The court search and seizure standards have evolved from the conservative physical penetration rule to the more liberal, right, reasonable expectation of privacy standard. And opponents of the exclusionary rule argue that letting a guilty person go free is too great a price for society to pay just because a police officer violated search and seizure guidelines, right? I mean, they did find illegal activity. This is a criminal after all, right? And we can't have criminals walking the street. Supporters fear that if the exclusionary rule is eliminated, police will have no incentive to respect the law. A 1983 study that was discussed by the court in that Leon case estimated that as much as 2% of all felony arrests are lost at any stage in the arrest disposition process, including trials and appeals, because of the exclusionary rule. The rate of lost arrests is somewhat higher in drug and other possessory offenses and much lower in violent crimes. So, 2 out of 100 cases, the police violate a rule and criminals go free. And it's higher in these drug cases. The controversy of the exclusionary rule illustrates that politics applying the Bill of Rights to the state. So we see the incorporation politics in Wolf and Mapp, as well as the politics of applying legal rules to specific fact situations. The present court divided 5-4 in a majority in favor of limiting the reach of the exclusionary rule and allowing all of these exceptions. Future Supreme Court appointments could make a difference in this or other areas of the law. And we'll talk more about that after the death penalty election. We'll get into the specifics of the 9 justices. We'll talk about Justice Stevens, and we'll really talk about Justice Kennedy, who is the one who makes the 5th vote on the current court in a moderate conservative direction most of the time. Though sometimes he does side with the liberals, but he's mostly a moderate conservative. So we'll talk about that at the end of the death penalty election. Out of time.
But you can ask questions if you got.
It's so simple. There are no questions.
Just out of curiosity, I don't know of any specifics, but how is the Patriot Act falling in line with a lot of these things?
Such a simple question.
Well, the Patriot Act is a simple bill. And it's been revised many times since then. And what the Patriot Act is just revisions of existing laws that are already in the books. So, I mean, it would depend on specifically what you're talking about, but the question really is, by federal statute, what you're saying, can you change, I mean, we're talking about, yeah, can you allow for, say, wiretapping, right? A telephone conversation, can you change that by federal statute? Or is that, I mean, this is where you have this constant. What I try to tell students is that the law, one of the reasons why the law is not clear is because on the one hand you have rights and liberties, like for example, protections of search and seizure, on the one hand, for freedom of speech or whatever it is. But on the other hand, the state has something called the police power, and it's the inherent authority of the state to protect the health, safety, welfare, and morals of its people, whether that's by protecting us from terrorists or protecting us against criminals or whatever it is. And so these are both legitimate legal claims, right? Claims to authority, rights and liberties on the one hand, and police power of the state on the other hand. And where you draw, it's a balancing test. There's not one, it's not one or the other. And so courts are constantly weighing competing claims. And that's really what you're talking about, I think, with regard to this Patriot Act provisions that are controversial. Rights and liberties on the one hand, individual rights and liberties, and the police power of the state to protect us. It's just not clear where that falls. And I can tell you that there is no area of the law that is absolute. Even the First Amendment, even freedom of speech. And I have that lecture on my website if you want to look at it. You cannot, as Oliver Holmes famously said, right, shout and fire at a crowd of deer. That's because that could create panic and harm the people. So you can prohibit that. But if the theater is empty, can you shout fire in it? Absolutely, all day long. So it's contextual. So everything is contextual. So the answer is it depends, right? Can they tap your phone? Well, it depends. Who are you calling and why, right? And what is the context? Are we in a war on terror or not? I mean, so these, and so judges take that into consideration in interpreting the law. The law is contextual too, and judges make reference to that in their opinions. They say times have changed, or things are different, or they will take context into account. So there is no clear and easy answer here, and we come right back to what Justice Brennan said, right? You have to have 5, right? 5. The court is divided 5-4 on all these issues, right? So that reasonable people can disagree on what the Constitution requires on these matters. And it's not pretty to think that there's one guy who makes all the decisions for us. We'll talk about him. It's Justice Kennedy's world, and you live in it.
I'm really glad that you have opinions on the court today.
No.
We actually are, you're not going to have to listen to me. Lunch is here, so we're going to do lunch, and then we'll pick up in about, what did I give you, 45 minutes on the schedule? We'll pick up in 45 minutes. Lunch is right out the door.
Somebody was right up my daughter's alley. She spends her whole life with, can we get this, can we do that?